Hello, everybody. How are you doing all today? I want to talk today a little bit about the green card, how easy it is to get, how difficult it is, what happens if you have certain immigration history. Can you go ahead and get your green card? I'm Carlene Ponence, immigration attorney, and today I'm going to just do questions and answers, okay? So if you all are listening and you have any questions, go ahead and send it to us. But right now, I have these questions that have came to me, and I want to talk about them a little bit. I am married to a citizen, but I have an order of deportation. What should I do? Okay, so if you're married to a U.S. citizen, just remember that the fact that you're married to a U.S. citizen does not erase your immigration problem. If you have an order of deportation, you have to resolve the order of deportation in order to get your residence. So if you have an order of deportation, the first thing that you should do is do a motion with the court to remove the order of deportation. You need an order from the judge terminating proceedings, and then you can apply for your residence. Now, the question often comes to me, can I go ahead and apply for my residence and then resolve the order of deportation? Yes, you can, but it's better to resolve the order of deportation first, then apply for your residence. We have in the past applied for the residence and then resolve the order of deportation, but under this atmosphere where things are a little bit more looked at with a lot of scrutiny, I would highly recommend that you resolve the order of deportation with the immigration court, then apply for your residence. Now, I'm assuming that if you want to adjust your status here, it's because you came in legally. If that's the case, remember that you have to file the I-130 and the I-485. Also, remember, you must have a proof of your legal entry. If not, you're not able to file the I-130 and the I-485 here. If you did not enter the country legally, then what do you have to do? You'd have to leave the United States in order to do your case with the embassy. This is so important. I think we have a few technical difficulties here, but I think we're okay. I think we will just continue. Here's another question. I live in Texas. I applied for my green card, but I got my fingerprint appointment in Florida. What should I do? This happens all the time. Sometimes immigration makes mistakes. So what should you do? So if you apply for your green card, remember, when you apply for your green card in the United States, because you entered legally, you're married to a citizen, you have to do fingerprints. So sometimes, yes, immigration will make a mistake and you live in one state and then you find out that you have your fingerprint appointment in another state. Now, here's what I want to tell you. If you can fly, and I know it's costly, to the other state to do your fingerprints, by all means do it. Sometimes you can take the fingerprint appointment to the local immigration office in your state. Let's say this person lives in Texas. Take it to your state, the local immigration office in Texas, and say, look what happened. I live here. My address is all my address on the application says Texas, but immigration made a mistake and sent me my fingerprint appointment in Florida. It's very difficult for me to fly to Florida. First of all, it's costly. I have children and I have to work. Can you help me? A lot of times the immigration office will help. They'll say, okay, no problem. And they'll help you and you can do your fingerprint appointment there. But if you run into a problem, please try to go and have your fingerprint appointment done in Florida. Don't delay and don't miss your appointment. Sometimes people will say to me, oh, I already did my fingerprint 6 months ago, 5 months ago, 3 months ago. No. If you get an appointment to do your fingerprints and you are applying for your residence, please do so. Please do so. It's very important. The other thing is, if you miss your appointment, you can get an order of deportation. Immigration will not process your case if you miss your fingerprint appointment. So it's very, very important that you go and get it done. Okay, the other question is, I applied for my green card, adjustment of status, and now I have an emergency and I need to travel. What should I do? Now, in this situation, I'm assuming that the person applied for the I-130 and the I-485. Because if you just apply for the I-130, you are not eligible to travel. Now, if you applied for the I-130 and the I-485, because you can adjust your status in the United States, yes, you can apply for a travel permit to leave the country. Now, there are people who say to me, well, I filed my applications, therefore I can travel. You cannot travel without a permit to travel. That's a different application. It's Form I-131. If you did not file Form I-131 with your adjustment of status application, please do so before you travel. If you have an emergency, you can call immigration, and immigration will give you an appointment, an emergency appointment. Now, what is an emergency? If somebody's sick, if somebody's dying, you need a letter from a doctor. In the past, a job situation could have some count for an emergency. Nowadays, it's very difficult to convince immigration that a job issue, or you need to travel for a job, or you need some emergency for your job. It's sometimes a little bit harder to convince them to give you a permit. But if there's an emergency, a real emergency, a medical emergency, and you need to travel, you can do so. But please remember, get the travel permit before you leave the United States. The travel permit will enable you to leave and enter without a problem. If you travel without that travel permit, what will happen is immigration will consider your application abandoned. That means that you cannot have your residence, because immigration will say, you know what? We're going to deny your application. So it's very important that you do so, okay? Remember, Form I-131, travel permit if you have an emergency and you need to leave the United States. That's very important. The next question I have is, I enter the country legally and I'm married to a resident. Can I do my adjustment of status here in the United States, or do I need to leave the country? Okay, a few issues. If you enter the country legally and you're married to a resident, there are times that you can do an adjustment of status in the United States if the priority date is current. And what does that mean? If immigration is working on the date that you filed your application. So let's just say immigration is working right now on April 2026. You entered legally and you're married to a legal permanent resident. Chances are you can adjust. But let's just say you filed your application today, but immigration is working on cases that were filed in 2024, 2025. You cannot adjust your status, although you entered legally. Well, a lot of times, people who are married to residents, they need to do a waiver. And then with that waiver, they can leave the United States and have their cases done in the embassy. That's option number one. Option number two is you can file the I-130, but if you just entered right now, stay within the time that immigration gives you. Immigration at the airport will give you 3 months or 6 months. Stay the time and then allotted time, leave the country, and then you can go back and forth until immigration is processing your date, your priority date. So that means that you won't stay illegally. If you already have stayed illegally, you're married to a resident, chances are that you're going to have to apply for a waiver, and you will have your case processed at the embassy in your country. Now, the other option, the third option, is if your spouse becomes a citizen, you can do your adjustment of status here in the United States. But that means that your spouse has to become a citizen, and you have to remember to show proof that you enter the country legally, and then you will be okay. But just because you enter legally and just because you're married to a resident doesn't necessarily mean you can process your case here in the United States. You have to look at the different options, speak to an immigration attorney, and to help you to evaluate your case. Okay, the next option. I entered illegally. The other question was I entered legally. Now this one is saying I entered illegally and I'm married to a U.S. citizen. Can I apply for my green card here, or do I need to leave the country? Okay, so if you enter the country illegally, although you're married to a U.S. citizen, you have to leave the United States in order to process your case outside. That means that you have to do a waiver. Now, there are two types of waivers. There's a 212 and the 601A. If you have an order of deportation, remember you need to do the 212. If you do not, you need to do the 601A, not 601, the I-601A. When you do the I-601A, if you get it approved, then you can travel to your embassy and you can have your case done at the embassy in your country. Now, that is where NVC comes in. And people say, well, what is NVC? The National Visa Center. The National Visa Center is the entity, the office that processes your case before your case is sent to the embassy. So when you get your I-130 approved, you're living in the United States, you get your I-130 approved, the National Visa Center will start sending you letters. And the letters will say, pay your fee. It will also say, fill out certain forms, upload certain forms. When all the forms are uploaded in a portal, the NVC portal, and you fill out all the applications that they require, then and only then, you can send your application. They will send your application to the embassy, and the embassy will process your case and send you an appointment, and then you can leave the country and have your case processed outside. But remember, if you were living in the United States illegally, it doesn't matter if you came in legally, but if you're here illegally, that means you overstayed your visa. If you're married to a US citizen, that does not give you the right to process your case here. You need to leave the United States in order to have your case processed. So the green card, is it easy? Well, nothing is really easy, but it's not difficult either. You just have to remember to evaluate your immigration status. What is your immigration status? Do you have an order of deportation? Do you have a record? How did you enter the country? Is your spouse a resident? Is your spouse a citizen? All these factors you have to take into consideration before you process your green card, and it's not difficult. So follow us for more information regarding the green card, and stay with us, follow us. We're going to be giving you information on how to get your green card, how to process your green card, how to live in the United States legally, and just follow us and subscribe, and we'll be in touch. Thank you.